Our first case this morning is Wilmore Moody versus Dakir. This is a 15-minute mini oral argument on the application. Welcome, counsel. You may reserve some of your time if we do not use it up, but we ask that you do your best to keep track of your own time. And you have 2 minutes of a free fire zone if you wish. And begin when you're ready.
If the court please, Your Honors, Scott Mandel representing the appellant along with Julie Furshman. Your Honors, first, if I may, I'd like to thank the court for its courtesy and also brother counsel. I had a family conflict, and I very much appreciate the indulgence in allowing this to go first today as opposed to last. Your Honors, the issue that this particular case frames is an insurance policy that has been rescinded in effect. And I'd also like to reserve 2 minutes of rebuttal, if I may. And I respectfully submit that the answer to that question touches on what is really established legal doctrine, rescission. And if the policy has been rescinded, we know that the policy is void ab initio, and that means that it was never in effect. And if it was never in effect, it could not have been, I respectfully submit, in effect at the time of the accident. And for that reason, we ask that this court reverse the Court of Appeals and the ruling in this case that makes at least I respectfully submit, an incorrect analysis of what is in effect by talking about whether it's factually in effect or legally in effect. What we know is the doctrine of rescission is an established doctrine, and what it means is void ab initio. Your Honors, I'd be happy to entertain any questions. I wanted to make that fundamental point. I don't believe I need 2 minutes to do that.
Please continue.
I'll reserve my time. Thank you. If there are no questions.
Well, I'll ask a question.
Okay, I'm sorry. I didn't think you could make it that easy on me.
Good morning, counsel.
Good morning.
And this is something that I've just been thinking about, and it wasn't really in the briefing, but this is just something I wanted to have a better understanding of, and perhaps maybe we should do more briefing on it. But when you have a large family, like you have in this situation, and you have kind of extended family, you have relatives, you have friends, you have a number of different people. The question that I have is, what defines a resident, right? So for example, like what is it that makes someone like a lawful resident? If if let's say I have a large family, or I have friends, and I have someone who's, 17 or 18 that's living with me, but they're living temporarily, what is the onus? Am I required to basically notify my insurance company if, let's say, a friend's child stays at a person's house? Is that homeowner now required to now notify insurance companies if there's a change in that situation?
That's a very intriguing question. And you're right, there really has not been briefing on that particular issue. And what I would expect with something like that is, no, if someone is transient, if they're coming into a household, they're not residing, living in that household, they're spending the night, it's an out-of-town family member who's there for a week, that's not a resident of the household. And I know of nothing.
Then what would we use as I guess that's my question. Like, if they don't vote, it's like, especially if you're dealing with a large family that has extended relationships with lots of people, right? And it's custom, like with large families where like someone, like a cousin's gonna come and stay with you. But they don't necessarily live with you, but they're staying with you. And I guess that's my question. Like, what is it that constitutes a resident? Should we use the same standard that you're only a resident if that's where you vote? Or if that's, I guess that's my question. And then, because if you were to say that a person is transient, then how do we define that? Is that a month, a year? Maybe they're there just during the college years. Maybe they're studying at Wayne or Dearborn or wherever, and at University of Michigan Dearborn or wherever. And Are U of M Flint, or I'm just trying to figure this out because I think this is really complicated.
And again, Your Honor, I'm going to try my best to answer the question. I have to acknowledge I haven't
Right, no, I
studied.
totally understand. That's why I'm thinking maybe, is this something that maybe we have to look at closer or ask for briefing on?
Well, I'd be happy to do that, but if I can try to respond to
Sure,
the court's question,
of
at
course.
least to the best of my ability,
Please.
at this point. The court, I'm sorry, Justice Bernstein, you mentioned as an example voting. At what point are you a resident being able to vote in a particular locale? If you're there for a day, a month, or something like that, and it's not your established place of where you live, I don't believe that would be a resident. I don't believe that this is a Herculean test that is being imposed upon the insured. With respect, you've got the Court of Appeals decision that explores the particular facts of this case. And in this case, 2 of the 3 judges in that particular panel concluded that this was an intentional misrepresentation. I realize the counsel won't agree with that, but that's what the Court of Appeals concluded, that it was intentional, that these were people who lived in the household. One was older, and a driver residing in the household, and that really wasn't questioned below. But as far as where that break point is, I would suggest a guide for that would be whether residence has been established to vote. Now, that doesn't mean that every person must be a registered voter, but at least as a litmus test, certainly someone who's just coming through would not be enough. A large extended family where somebody comes in for a relatively brief period of time would not be enough. A year, I would think that would not be a particular challenge if somebody's living in a household for a year or more, but I don't know that there's a bright line number of days, as an example, number of months or something like that. But I think that would be a point that we could look at, and I'd be happy to provide the court with additional briefing if the court wants. But I have not admittedly looked at that particular issue.
Counsel, thank you, and thank you for answering my question. I realize it was a little bit challenging, and you did a great job, and thank you for that.
Thank
Counsel, I have a question. I'm wondering if you have thoughts about what role equitable considerations might play in this analysis. In Bazzi, we said this sort of legal fiction of a rescission of a contract, taking everybody back to this point where the contract never existed, and equitable considerations weigh into or should be considered in determining whether an innocent third party has the ability to proceed on first party benefits. Are there similar, or should there be similar sort of equitable considerations in the circumstances of this case where you have a negligent tortfeasor who is sort of, in some ways, getting a windfall by having happened to have hit or injured somebody who then the insurance company later rescinds their contract?
Sure. It is an equitable doctrine first, so do equitable considerations come into play? The answer is yes. Justice Kavanaugh, with respect to your question, the answer is yes to that. With respect to the notion of innocent third parties, I respectfully submit that this court in the Bazzi case said, no, that doctrine as a result of Titan has been abrogated, and we can't look at that test. So the focus here is the underlying matter between the insurer and the insured. Now, I understand the particular facts of our case are in respect to the accident. We have someone who's innocent. Ms. Wilmer Moody is innocent in that context, but that's not how we apply the doctrine of rescission. We're looking at between the insurer and the insured. And in that context, Ms. Wilmer Moody would not be an innocent party. Again, we've got the record here that the Court of Appeals has framed, and the conclusion there, again, what is disconcerting about the Court of Appeals decision is the Court of Appeals accepts that there's rescission. It applies. They don't quarrel with that notion. And they jump over the question that you're framing here by saying rescission applies, but we're going to be looking at a quote-unquote legal fiction, and we're going to be concluding that it was factually in effect. I don't believe that that is a proper legal analysis.
I agree. I agree with you that the plaintiff is not an innocent party with respect to the rescission between her and Everest, right? So that is not so much the consideration, but that is, as far as I can see in rescission and looking at these policies, it's all framed as between the parties or as to the parties. Why does this third party, who just completely unrelated to the contract or even the idea of rescission or how that all gets weighed, why somehow are they then benefiting from this equitable legal fiction that is between these two other parties?
Yeah, great question. And the reason for that is because of the legislature. You know, same context. I realize that this would be the extreme example. Let's make it an innocent, in the sense of driving behavior, uninsured motorist who is completely uninsured. They've done nothing wrong other than, admittedly, they didn't buy insurance. They shouldn't have been behind the wheel of the car. But they're sitting there in the same position Ms. Wilmer Moody is and is rear-ended by somebody else. As far as the accident itself, they've done nothing themselves wrong that contributed to that. The legislature has answered that question. We could argue back and forth policy-wise whether that is or is not appropriate, but the legislature has said to recover damages, you've got to have, in effect, at the time of the injury, the policy of insurance. And again, that was my opening remark. We would be really upending an established legal doctrine. I understand some courts have referred to it as a legal fiction, but the law is laced with, if we're going to use that kind of pejorative term, with legal fictions. Corporations are people. That's a legal fiction, but we have established doctrine that we can rely upon.
Okay, I have one last question. So the idea of, or the remedy of rescission is at the discretion of the insurer. So we then have, what about if there is an insurer different than Everest, who doesn't rescind policies for any number of business reasons? You know, Everest has their own history and policy behind rescinding contracts. So now we not only have a tortfeasor, right, a negligent driver injuring somebody, but you're now dependent on whether or not that person's insurer actually is rescinding policies, even if they had a basis to. So, I mean, isn't this just, it seems to be unworkable as opposed to the rule that maybe it's a legal fiction between the two contracting parties, but at the time that the person was injured, there was a policy in effect.
Well, okay, there were a couple questions there, if I can try to respond to those. That gets into what the Court of Appeals is talking about, factually in effect and legally in effect. There was a policy in effect. Okay, I understand that, but it was not in effect if we're going to be applying the doctrine of rescission. And the question really is, does that doctrine apply or not apply? If an insurer elects not to rescind the policy and has carried on as though the policy were in effect, they've waived that. And admittedly, we're the ones who are benefiting, but that's not us, it's the legislature.
Would your client then be able to say they should have rescinded the policy and therefore you didn't have insurance in effect at the time?
I'd say no to that. And the reason I say no is that we've got a case that at least touches on that, the Burton versus Wolverine case, where an insurer there wanted to have it both ways. And the insurer, rather than rescinding the policy, decided they treated it as a cancellation, they held on to the premium, and they wanted to take advantage of a period of time and get the money in. And the court said, no, you can't go back now and say it's rescission when you've acted otherwise. So in that sense, the insurer, whether or not it's rescinded, their actions do have a role here. But once that decision has been made, and that's the odd thing about this case, it comes before this court with that decision actually being affirmed, that the trial court decided on the record before it, rescission applied. That's what the trial court decided. The Court of Appeals agreed with that. And again, these are terrific questions, but the record of this case is that a rescission has been established. It's already there.
Sure, but
And-
we're deciding a case to figure out how this works, not just for your case,
Oh,
but for other cases that come after it. And it seems to me that, whether or not it's rescinded and we're recognizing this legal fiction is in the hands of an insurer that may or may not decide to exercise that option. And then again, you have a third party who can or can't take advantage of that and escape liability for negligently injuring somebody based on somebody that, some transaction that they have no relation to.
And again, my response, Your Honor, is as this court is thinking about the other cases and the precedent that this is going to set, what we have is a situation where the rescission itself has got to be there. This doesn't work without there being rescission. So the only way that this works is if there's a rescission. And I would respectfully submit that Mr. Zakir, without the rescission in place, again, we're not in a position where we can establish rescission unless there's rescission itself. So if the insurer has elected not to rescind the policy, the insurer has carried on and has waived that, then I don't think, again, that that's a rescission. But what we have here is a rescission.
Right.
And again, I know you're concerned about establishing precedent, but that is the touchstone, and I believe it is even more dangerous to say rescission is not rescission. What the Court of Appeals has done is thrown a significant carve-out to rescission. And so effectively, rescission now is factual versus legal, and that's just, I respectfully submit, a very dangerous plank to be walking down.
I appreciate it. Thank you for
All
answering
right,
that.
since you're not coming back on rebuttal, we used all your time when you almost had 14 minutes.
Oh, I'm sorry. Well, I was
No,
responding
that
to a
was
question,
me.
Your
That
Honor.
wasn't
I
you.
just want to ask, maybe I missed it, but is there any case law, published case law supporting your position that rescission of an insurance contract allows a third party to use rescission as a defense against liability in a separate lawsuit between the former insured and that third party?
No, I can't offhand, no, I don't believe the parties have briefed such a case. That's why this case is here, Your Honor.
Okay.
Thank you.
Thank you.
Good morning, Justices. May it please the Court, Keith Banka on behalf of the plaintiff appellee, Dora Wilmore Moody. Brother Counsel focuses on the in effect language of the statute. The important language of the statute is at the time of injury. The legislature chose to set the inquiry at the time the injury occurred. They could have used language, broader language, in effect for the injury or for the loss. They didn't. They chose at the time of the injury occurred to set this inquiry as to when you have to have this security in effect. And Brother Counsel talks about the law and equity, talking about rescission, voiding ab initio. But all of that case law talks about instances going forward, right? It eliminates the contract and voids ab initio going forward. So no party can rely on that contract in future transactions or anything in the future. It doesn't speak to anything that any contingency that's happened in the past. And I believe Justice Saras, his questions kind of touched on that. There is no case law that says a rescission can void a contingency that's already occurred as to a third party. And that's what's not here. And in that case, if you allow that, it opens up a can of worms on the other end. For instance, oftentimes before you'll have a rescission, you'll have some payment on a claim. And if the no-fault insurer makes some payment on that claim and then rescinds, do they have a cause of action against the providers now to say you have to pay us back? Even though the provider had nothing to do with the fraud, had nothing to do with anything except treating a patient, making a claim, and receiving payment, now do they have to give that back? Again, also, what if this case settled, the BIN settled, and then we went to trial on PIP and it gets rescinded? Does the third party, would Zakir have a cause of action to get recovery from Ms. Moody after a settlement has been reached if there's a subsequent rescission? And that's the problem here. You're muddying up plain statutory language with all of these equity considerations. And that's what it is. It's an equity consideration. They want to avail themselves of an equitable principle, in this case rescission, to say that that rescission now absolves them of a legal responsibility. And so even though they don't want to come in here and say they're trying to use equity, they actually are. And I think that's the way the court would see it if you had an instance where there was a rescission and then a no-fault insurer went after a provider directly for repayment. I think this court would probably treat that along the lines of Bazzi and do equitable considerations. Well, should this responsibility be put on the provider, even though the insurer could have investigated, could have rescinded before making the payments?
Under what basis was plaintiff precluded from recovering PIP benefits in her first-party case against Everest? Was it rescission of, a result of rescission of the insurance contract with Everest, or was it the statutory provision of 3113B, which bars a claim for PIP benefits if the claimant was uninsured at the time of the accident?
It was rescission, and the case, this is the typical business practice of Everest. They have a confusing and somewhat misleading application process that will ask you to disclose drivers in the household, then ask you to disclose individuals over 14 in the household. And at the time Ms. Wilmore Moody purchased her policy, her daughter, her 19-year-old daughter, was living in her household. And so this was an instance where Ms. Wilmore Moody fell victim to what we call the Everest trap, and that's why the policy was rescinded, because the court felt that the failure to disclose the 19-year-old daughter in the household amounted to a material misrepresentation.
Wouldn't 500.3113B also stop that first-party case from proceeding?
That's a good question. Generally, these cases aren't decided on that statute because they're not, you make the claim for PIP benefits and then it's a contractual remedy, the rescission, and the insurance companies don't get into the statutory remedy of driving without a policy. And I've never actually heard that defense from an insurance company when they're making the arguments. Basically, they say it's all contractual. We have an equitable right to rescind this contract and not pay benefits. So we don't get into 3113. But in any event, this comes down to very simple statutory construction. They have they have no authority that says you can use a decision in equity to then influence a statutory contingency, especially once that contingency has already been triggered. So the problem here is that the legislature, for the defense, is that the inquiry is set in time. As soon as the collision occurred and she had a valid proof of insurance, she was entitled to non-economic damages under 500.3135. And this court should uphold the Court of Appeals. Thank you.
Thank you very much. No other questions? The case will be submitted. Thank you.